Hello, folks. I wanted to kind of go through this lecture and have you guys just listen to it at your own free time if you wanted to. That way I don't really take up Zoom classes for this. And I can just do more of like answering questions, or we can go through free response questions or whatever during that Zoom time. So if you were in last Wednesday's Zoom meeting, you can probably skip a few slides on this, or skip a few minutes anyway, because that's where we got to last week. So I first do have to apologize if you hear my dog barking in the background. She's not currently barking. However, she probably will lose her mind soon about something. Okay. So this is Civil Liberties, Chapter 14. The first thing we're going to do, though, is we are going to go through a very, 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 I can't stress very enough, important difference. And that's the difference between civil liberties and civil rights. And I'm telling you, like, even on a shortened free response test this year, I believe you'll have to know this. So civil liberties come from the Bill of Rights. So all 10 of those amendments are what we call our civil liberties. And what they do is that they guarantee freedoms for you, and they place restrictions on what the government can and can't do. For instance, if you think about like the Second Amendment, so the right to bear arms. So your civil liberty, although people will say it's my right to have assault rifles. Okay, sure. But like, you're saying it wrong. It's actually your liberty. It's not your right, but that's neither here nor there. So civil liberties, though, means that like you have that freedom to do something. So you have the freedom to have a gun, and the government cannot take that away from you. So civil liberties place restrictions on what the government can and can't do. Civil rights are designed to provide protections for citizens. So that very first one was the 13th Amendment, which abolished slavery. The 14th Amendment is a hugely important amendment for civil rights, arguably the most important, because it has the due process and the equal protection clause. Equal protection is really where civil rights come from. So it's, no state shall deny any person due process of law or equal protection under the law. So equal protection means I'm making laws that treat all people the same. So I'm giving an equal playing field. So those are civil rights. So civil liberties provide protections from the government. Civil liberties or civil rights, provide protections like by the government. Okay. Very important. So civil liberties examples, like I said, list off the Bill of Rights. Those are your civil liberties: freedom of speech, the right to privacy. Privacy is interesting, though, because it's actually not in the Bill of Rights. It was established by what's called a penumbras. So they took the first, the third, the fourth, the fifth, and the ninth amendments. I don't think I'm missing any of those. In a case called Griswold versus Connecticut, which was actually about your right to privacy with respect to your marriage. And it was actually about had to do with reproductive rights and that sort of thing. So there's several cases like that. So there's Griswold, which established right to privacy between married couples, and then Roe versus Wade, which used the right to privacy to establish the right for women to have an abortion, and then Planned Parenthood versus Casey, which which also used privacy to establish the right to use birth control. Anyway, so the right to privacy, not necessarily within an amendment itself, but has been created using a bunch of different amendments. The right to be free from unreasonable searches of your home. That's the Fourth Amendment. Right to a fair court trial. That's the 6th and the 7th. The 6th is criminal cases. The 7th is civil. Right to bear arms, of course, we talked about. Civil rights. So the main idea, again, like I said, is a basic right to be free from unequal treatment based on certain protected characteristics. And that word protected is very important. because not everything about you is a protected characteristic in the eyes of the federal government. So what are protected characteristics are things like race and gender, disability. You think about these things as things that you can't help. But then it also includes things that technically you can help, like religion, right? So you can choose to be a different religion if you want to, right? You might be born a Hindu, but then you want to convert to Judaism. Okay, fine. There are other certain things that arguably cannot be helped that are not protected yet at the federal level. Things like sexual orientation and gender identity. A lot of states do protect that. In fact, Virginia, literally just yesterday, their governor signed into law like their own Civil Rights Act. But so a lot of states have Civil Rights Acts that protect those. But if they're challenged at the federal level, they have not been upheld. Masterpiece Cake Shop, that ruling is the one that I can think of that like just happened recently. And that was when a gay couple went to ask a baker to bake a wedding cake for them. And he said, no, I'm not going to. My sincerely held religious belief is that that is wrong. And you can't make me. And so the couple sued the baker under the Colorado Civil Rights Act, which did include protection against unequal treatment based on sexual orientation. So it was like a civil rights case versus civil liberties case, because you have on the one hand this couple arguing like, you are a place of public accommodation, meaning you're a business. You cannot discriminate against me because I'm a homosexual. And then you have this other end of it, which is the baker invoking civil liberties and saying, well, I have free exercise of my religion, which says that I don't think that what you do is correct. And so it was a very interesting argument. And the civil liberty of freedom of religion ended up winning over that civil right of being free from discrimination based on sexual orientation. And it might be simply because it was a state law rather than a federal law. So if I went up against like the Civil Rights Act of 1964, which is like the main piece of federal civil rights legislation, that's the original one that says you cannot discriminate against anybody based on their race, their gender, their national origin, their religion, etc. If they were going up against that, might have been a different story. But like civil rights and civil liberties collide all of the time. And it's up to each different court to sort of interpret which one wins out in each one of those cases. And this is why this is like my absolute favorite unit. And I'm super bummed that we're not actually doing this in class because I really enjoy the arguments that people can get into about these. And they're all super valid, whether or not you agree with them. But like, you have to understand that, and I think we've talked about this a million times in class, just because you don't agree with something doesn't mean it's not valid, right? So there are some interesting discussions on that. All right. So examples of civil rights, like I just referenced, the Civil Rights Act of 1964, that's the big one. So no discrimination based on race, gender, national origin, religion, etc. There's been a lot of different amendments to that as time has gone on as well. The Voting Rights Act of 1965. So for those of you who were doing that free response question last week or tried to and looked at that first one, which is about voting, the Voting Rights Act of 1965 was what Part B was referencing. And for those of you going, I've never heard of that. Yes, you have. We talked about it during the, I don't remember which unit it was. Whenever we talked about gerrymandering, we talked about the Voting Rights Act of 1965. So the Voting Rights Act basically said like you could not discriminate against people, at the polls. So you can't make it harder for somebody to vote based on, again, these things like race, gender, national origin, etc. The Americans with Disabilities Act, the ADA as we call it, an offshoot of that, which you might be familiar with, is IDEA, which is the Individuals with Disabilities in Education Act. That was also, I believe, 1990, and it was an offshoot of the ADA. So you can't treat somebody differently in school simply because of a physical disability or a learning disability. And same thing with the ADA. If you guys remember that federalism scavenger hunt that you did, where you had to you saw the Braille on there and the handicap parking and that kind of stuff. A lot of those were ADA regulations. So you have to make things accessible for people with physical disabilities. The Equal Pay Act was actually passed in 1963 and is not really widely enforced, but it was a congressional act signed into law by JFK. And then various affirmative action policies. And affirmative action is kind of leveling the playing field for opportunities for groups that have been historically disenfranchised. And where you will hear, affirmative action referenced a lot is with college admissions. So there was actually several cases involving the University of Michigan back in the early 2000s about affirmative action. And because they had a really weird quota program that they did. And so a lot of that has been a strict quota program has been outlawed, but affirmative action itself is designed to lift up groups of people. In that instance, it was African Americans, sometimes it's women, people who haven't necessarily been given the exact same opportunities as others, and help them move along into these opportunities, such as college, or one of them was U of M med school, I believe, that they were trying to get into. So just basically higher education or employment opportunities is where you see affirmative action. All right, so your basic distinction, just to review real quick. So civil liberties are protection from government action. So civil liberties are things that the government cannot do or cannot take away. And they protect individuals. Civil rights are protections given by the government. So they're things that the government must do to create equal conditions for all people. Notice I say equal conditions. Equality of opportunity and equality of outcome are two very, very different things. And the easier you understand that, the better. As long as the government creates conditions that are equal for people, then it is up to people to make of it, what they can or what they want to. But civil rights protect groups rather than individuals. You've probably, if you're on social media at all during this time, our governor continues to enact executive orders that sort of, pile on this stay-at-home order. And if your newsfeed on whatever social media on looks anything like mine, people are up in arms about she's taking away our freedom and our constitutional rights. Oh my gosh. I had a guy try to tell me that his right to assemble was being taken away because he can't go golf. And I said, okay, you're missing the point of your First Amendment right to peaceably assemble, which actually means that you can assemble in protest or to defend beliefs. That's the spirit of that amendment. Assembling with three of your buddies to create a foursome to go golf, you're doing it wrong. That's not what freedom to assemble means. And then I had others. Well, when I get to free exercise clause, I'll talk about that one too. So, all right. So anyway, those are your basic distinctions. Now, going back to the beginning of the year, real quick, you were given some rights in the original Constitution, before the Bill of Rights, the writ of habeas corpus, which means the government can't throw you into jail, and I'll tell you why. Can't pass bills of attainder, which means it can't sentence you to a punishment without a trial. Can't pass ex post facto laws, which means you can't be charged with a crime after a law is made. So before murder was illegal, if you murdered somebody, then they're you know what, you probably shouldn't do that. Let's make a law about that. They can't charge you with it if you did it before it was a law on the books. You can't get a title of nobility. Sorry. You were also guaranteed a trial by jury in federal courts, and you were in guaranteed privileges and immunities. Meaning it's kind of like the travel clause between states. So a lot of what we kind of talk about in the Bill of Rights was already in the original Constitution in a couple of different ways. However, if you will remember from our Federalist and Anti-Federalist debate, which seems like 4 years ago now, the Anti-Federalists wanted a Bill of Rights because they were the Anti-Federalists. Remember, were the people who were like, we don't want strong central government. We just got out of this like tyrannical craziness of King George III, and we're done. We don't want to do it anymore. And so, if we're going to get this central government, like we need to make sure that it can't take away our freedom like the last one did. So they said, we need a Bill of Rights. We need protection from the government. Federalists said no. They thought, first of all, that the states that had their own bills of rights, which most of them did, that was enough and it's fine. And they also thought that listing out protections would limit protections, meaning like, well, you have these 10 amendments, but it doesn't say anywhere in here that I can't, that the government can't take away, or that you have any like right to privacy, right? So, which is again, not in the Constitution. So, I mean, both of them obviously had some good points. The Anti-Federalists won that argument. The first 10 amendments were added in 1971 as the Bill of Rights. Okay, that's your little history lesson. I would know these. These are all of your Bill of Rights. Like just in life, you should know these. Plus, so you can argue with people on social media when they say that they're taking people's civil liberties away. But also, you might just at least want to have this as a reference point for like on your test. So Amendment 1, RAPS. So freedom of religion, assembly, petition, press, and speech or expression. Second Amendment, right to bear arms. Third, no quartering of soldiers during peacetime. So like the National Guard, if we do invoke them or in any measurable way in Michigan, they can't just like come knocking on my door and be like, hey, we're going to stay with you. So although maybe they could at this point. I mean, it's not necessarily wartime, but certainly we are under a state of national emergency. I don't know. That would be an interesting one to do. That's the only, third is the only amendment that is, or the only Bill of Rights, amendment in the Bill of Rights that has not been individually challenged in the Supreme Court. It's been used in others, like it was used to establish a presumption of privacy, but nobody's ever taken like the Third Amendment to the Supreme Court. Highest it's ever gotten is Circuit Court of Appeals. Anyway, that's your little trivia for today. Fourth Amendment, no unreasonable search and seizure. Fifth is grand jury, right to a grand jury, which again, a grand jury decides whether there's evidence to go forward. A grand jury does not decide guilt or innocence. A petite jury decides guilt or innocence, but grand jury decides if there's enough evidence to actually go to trial. I guarantee due process, which means that you have to, like the government has to follow certain steps in order to, arrest you, detain you, try whatever. When you hear due process of law, it means like we have to follow what the law says. And there's two different forms of due process, which I think we get into in chapter 15, but there's like make the laws fair. So it's called substantive due process. So the substance of the laws has to be fair. And then there's procedural due process, meaning that procedures you follow to carry out the law have to follow a certain process. Anyway. Sorry. Double jeopardy means you cannot be tried twice in the same court for the same crime. Self-incrimination, so you're protected from having to testify against yourself in court. And the eminent domain clause at the end of the Fifth Amendment, which means that the government cannot take private property for public use without just compensation. So if they want to like build a freeway where your house is, they have to pay you what a reasonable buyer would pay a reasonable seller in order to capture that property. Sixth Amendment is right to jury trial and attorney in criminal cases. So like if your freedom is at stake. 7 is right to a jury trial in civil cases. So like if you're suing somebody. No, you are not, if you're a defendant in a civil case, you are not guaranteed an attorney. Sorry. Number 8 is protection against cruel and unusual punishment or excessive bail and fines. Number 9 is individual rights are retained outside of the list of the Bill of Rights. And then 10 is reserve powers. So anything that's not given to the federal government or expressly forbidden in the Constitution is given to the states. Excuse me. Okay. So it is important to note that the Bill of Rights originally only applied to the federal government. So like the state of Michigan, well, state of Michigan didn't exist in the founding, but you understand what I'm saying. let's do one that actually did exist. So like the state of New York at the time of the founding could not, like, they couldn't be held accountable for infringing on your freedom of speech. Like the federal government could, but the state government or local government could not. So it didn't, like, those applications of it didn't apply to like lower levels of government for a few reasons. The framers figured, number one, that the state governments would kind of control themselves in that aspect. Also that a lot of states already had their own Bill of Rights that applied. And then the central government, the federal government, was supposed to be like this sort of distant, like on an island type thing. And like those were rights that only the national government had to follow, not the states. All right, so then comes along this process of what's called selective incorporation. And it's a process of, quote, incorporating the Bill of Rights to the states. And you're like, okay, cool. What does that mean? Well, when one of the amendments in the Bill of Rights is incorporated to the states, that means that the states also are bound by that amendment. So it gives now provisions that say the states cannot infringe on civil liberties. It's important to know that not all 10 amendments are incorporated. First of all, a couple of them don't even make sense. Like you wouldn't incorporate the 9th and the 10th Amendment because they're not justice amendments. You can't see me, but I just put air quotes around justice. And that I love also, I just have to state this, that I'm like totally talking with my hands right now for no good reason because you can't see me. That's okay. And also that they were not all incorporated at once, which is why it's called selective incorporation. So it wasn't like the Supreme Court just said, you know, we're going to do today, we are going to decide that all of these apply to the states. Like it had to be, it was brought in case by case. And it didn't happen right away. It didn't happen until after 1868. Why? Well, because the 14th Amendment was the one that was used as justification for this doctrine of selective incorporation. And the reason why the 14th was and nothing else before that is because, like, so we have that due process clause in the 5th Amendment, but we have the same clause in the 14th Amendment, except it starts off differently. It says, no state shall deprive any person of life, liberty, or property without due process of law. So that's a due process clause. Nor deny any person within its jurisdiction equal protection of the law. So that's the equal protection clause, okay? Because it said no state, rather than like the federal government shall not, okay? That left the door open for people to take states or localities to court based on depriving people of their civil liberties, okay? So mostly the due process clause is used in selective incorporation of the due process clause of the 14th Amendment, I should say. And of course, the reason why there were no cases until after 1868 is because the 14th Amendment wasn't around until then. So there you go. So you needed that little part that says no state shall deprive any person of life, liberty, or property. Okay. We're not going to do that. We're that. We just went through all of this. Okay. Just talk about that. Okay, so the doctrine of selective incorporation, like I said. So the 14th Amendment was ratified in 1868. There were several cases that came through that tried unsuccessfully to use due process or equal protection clause in the 14th Amendment. So the first one, like these slaughterhouse cases, which was looking at privileges and immunities, it was ruled that did not apply to the states. Plessy versus Ferguson, which is a super, super, super important case. And it's not one of the required cases, but God, it's like such a huge deal because it was the one where the gentleman was like 7/8 white, right? So 1/8 African American. And he was on a train and he was told that he had to sit in the train car that was reserved for, at that time, what was called colored people, which of course we like don't even consider saying nowadays, right? But it's like that area for African American people. And so he sued and said that they were not providing, that state was not providing equal protection under the law. And the court came back and said, no, that's fine because they're providing a train car for you. And that's fine because conditions can be separate as long as they were equal conditions. So that doctrine started in 1896 as separate but equal idea and did not get overturned until 1954 with Brown versus Board of Education, where it was determined that, in fact, separate is not equal. And of course, that case had to do with education. So Brown versus Board is one of your required cases. Plessy is not. But it's very important to know as part of Brown that Brown overturned Plessy. So the first selective incorporation case, which is also not a required case, but it was called Gitlow versus New York. And it was in 1925. So the very first part of the Bill of Rights that was incorporated was the freedom of speech or freedom of expression clause in the First Amendment. So Gitlow actually lost the case, but the court did determine that he was allowed to have his right to free speech in a state law as well. So not just federal. So the case was versus the state of New York. And the Supreme Court said, yep, nope, sorry, New York, but you also cannot create laws that abridge one's freedom of speech. But again, then came back and said, but Gitlow, you're still wrong. Sorry, we're not going to rule for you, but this is like, you're right. It's kind of like the Marbury case, Marbury versus Madison, where it's like, yeah, Marbury, you do actually deserve this appointment, but we're not going to give it to you because it changed the original jurisdiction of the Supreme Court, and that's not going to happen. So cases work out that way a little bit. Kind of weird sometimes. Nope. Well, real quick. So the first, the second, the fourth, the sixth are, and the eighth are all fully incorporated amendments, meaning the states cannot also create laws that would infringe on these rights. The Third Amendment is, there's been, like I said, no Supreme Court decision on it. The Second Circuit and the Circuit Court of Appeals found it to be incorporated, but nobody's going to ever ask you about that. The Fifth Amendment is incorporated except for criminal prosecution or guaranteeing grand jury indictment for criminal prosecution. So that is just at the federal level. So if you're accused of a state crime, you are not necessarily guaranteed the right to a grand jury. Again, remember, grand jury decides whether or not there's enough evidence for a case to move forward. Okay, you're still guaranteed a jury trial, obviously. Sixth Amendment is fully incorporated. Seventh is not. So if somebody sues you in state court, you're not guaranteed a jury trial in that. But that's just for civil cases, not criminal. Eighth Amendment, excessive fines and bail, was actually just incorporated last winter in a case that had to do with, it was Timms versus Indiana, or Indiana versus, I think it was Timms versus Indiana. It doesn't matter. Anyway, so this guy was a drug dealer, and he was arrested for trying to sell like $10,000 worth of, I don't even remember what the drug was. It doesn't really matter. And as like punishment for that, the police seized his Land Rover. It was like a brand new Land Rover, which, by the way, brand new Land Rover is like, what, $90,000 car, right? So he actually took the police department to court saying that was excessive. That was an excessive fine because the drugs that he had were only worth $10,000, and they took his like $100,000 car. So that was excessive. And the Supreme Court actually ruled in his favor, and they said, yeah, you're right. You can't do that. So they just incorporated excessive bail and fines last winter, or 2 winters ago. And I was like so excited when it happened because I'm a nerd. And like I said before, 9 and 10 don't really count because they're not justice amendments. Now you'll see like 1, 2, 3, 4, 5 little asterisks here. And no, I just covered it. Sorry, but it says this is a required case. So the Second Amendment incorporation case, that's a required College Board case. It's McDonald versus Chicago. So the Second Amendment was not incorporated to the states until 2010, which is interesting. So states could have like very strict gun laws, and the state of Illinois and city of Chicago did until McDonald took them to court, and now they don't. And then the Sixth Amendment is the other incorporation case that is on, or that's a required case by the College Board. And that one's Gideon versus Wainwright. And we'll talk about that in just a second. Oh, here we go. Incorporation cases that could show up on your AP test. First one, Gideon versus Wainwright. Like I said, that was 1963. I will take this moment now to remind you that there is a document online that I created that basically has like this PowerPoint slide. So facts and question and ruling and significance for every single one of those 15 required Supreme Court cases. So just so you know, they're there, they're available, use them, have them with you on the day of the test. So, but yeah, it just has like all in one place. Whereas these go more by theme. That one goes by, here's what the College Board wants you to have. So anyway, Gideon versus Wainwright. So Gideon was charged with felony B&E, which means breaking and entering. And when he asked for an attorney, so he was charged with a state crime in Florida. Florida law at that time only gave the right to an attorney in capital cases, meaning like you murdered somebody. Well, Gideon didn't murder anybody or wasn't being charged with that. So he was not guaranteed an attorney. And so he couldn't afford to hire one. So again, there's no like DA, right? Like no defense attorney just given to you in Florida at that time. And so he represented himself in court. And as you can imagine, did not win. And so he continued his appeal up, and the Supreme Court took his case because he said, look, if I would have had an attorney, I might have actually won this case. Like, this is not fair because I have my Sixth Amendment right to a right to an attorney. Why doesn't Florida have to give this to me? So the constitutional question in this case is, does the Sixth Amendment right to counsel extend to state cases? At that point, it did not, but the court ruled unanimously for Gideon and said that, yes, absolutely, the Sixth Amendment guarantee of a right to an attorney applies to criminal defendants in state court through the 14th Amendment. Again, because he believed that his Sixth Amendment right was being violated and his 14th Amendment due process clause was also being violated, because by not giving him an attorney, they are trying to deprive him of liberty without due process. Okay, so that's kind of how that clause works. And of course, the significance of this case is that it incorporated the Sixth Amendment right to a jury trial in criminal cases. I'm going to pause for a second here too and remind you. So like, well, no, never mind, because we're not going to have a Supreme Court question, like comparison question on the test. The only way a court case will show up is perhaps you could use it as evidence and like the argumentative essay. All right. And then McDonald versus Chicago is the other incorporation case that is required by the College Board. Like I said, that's in 2010. So there is, there's a whole bunch of cases that were kind of like put into one on this. And it just took the name of one of these people that brought the case and one of the petitioners. So that happened to be McDonald. And this case was based on the DC versus Heller ruling, which again is not a required case. That was in 2002. But anyway, DC versus Heller was, it had to do with, it was like an off-duty police officer, and you weren't allowed in DC, you weren't allowed to have a gun that was like loaded and ready to go in your house, unless you had a special permit for it. And he did not have a special permit for it. So if you didn't, you had to like keep it broken apart and like not ready to go. And he's like, well, what the hell is the point? Ooh, sorry about that. It's like, what the heck is the point, right? So that was a DC versus Heller ruling where they said, yeah, no. You can have a gun ready to go if you want to. So anyway, so the McDonald case kind of worked off of this DC versus Heller case. And it challenged there were gun bans in Chicago and in Oak Park, which are both obviously cities in Illinois. And it stated that the Second Amendment should apply to the states through the 14th Amendment. Because again, you're depriving somebody of their liberty liberty meaning freedom to carry a gun, right? So the constitutional question is, does the Second Amendment apply to state law, excuse me, via the Due Process Clause of the 14th Amendment? The ruling is yes, 5-4 along ideological lines. And again, remember what that means is that like the conservatives all voted one way, the liberals all voted one way. In this case, the conservatives were the 5, the liberals were the 4. And they voted 5-4 for McDonald and decided that, yes, the right to bear arms does not just apply to the federal government. There should not be any state or local laws that limit that right either. And of course, again, the significance is it incorporated the Second Amendment into the states. Okay. Nope, we're not going to do that. Quick review. Difference between civil rights and liberties. Civil rights, remember, protections given by the government. Civil liberties are protections from government action. Selective incorporation is taking the Bill of Rights and like systematically applying them through court cases to the states as well, meaning that state laws cannot abridge your civil liberties. From which amendment does selective incorporation draw its justification? That would be the 14th Amendment. And in civil liberties cases, it is the Due Process Clause. So there you go. Oh, I could have just switched the slide and you would have known. All right. I'm going to stop this here and I'm going to start another recording after this. So I don't want it to be like 3 hours long because this is like 129 slide PowerPoint. It's insane. But so when next we speak, it'll be First Amendment freedoms and courts. So goodbye. Almost goodbye.